Okay, the Constitutional Court will today announce its judgment on the agreement between the SABC and MultiChoice brokered by the public broadcaster's then COO Hlaudi Motsoeneng in 2013.
It's live now, let's go there.
Actions to determine whether they constitute or give rise to a notifiable merger as defined in the Act, and whether proceedings should be initiated in the tribunal to impose appropriate penalties. A lesser interpretation, like that the CAC preferred, would effectively leave the Commission at the mercy of parties to the transaction. If those parties notify the Commission of a merger, then it has the full range of investigative powers. But were they to refuse to notify the Commission, even if they did so on purpose, the Commission would be powerless to investigate. And then the provisions that I've mentioned would become superfluous. Furthermore, the Court finds that the June 2016 order of the CAC did not strip the Commission of its ordinary statutory investigative powers. Those remained intact. There were also two applications before the Court to adduce new evidence on appeal. The Court finds that these should be dismissed. As for costs, this Court holds that the CAC erred in granting costs against the applicants in the October 2017 application. Before this Court, adverse costs are not warranted in the two applications to adduce new evidence. That judgment by Acting Justice Katri Sitilwane is concurred in by myself, Justice Fruneman, Justice Jafta, Acting Judge Justice Kolopin, Justice Madlanga, Justice Mhlantla, Justice Teron, and Acting Justice Zondi. Accordingly, the following order is made. 1. Leave to appeal is granted. 2. The appeal is upheld, and the Competition Appeal Court's order of 28 April 2017 is set aside. It is replaced with the following. A. It is declared that the order handed down on 24 June 2016 does not preclude the Commission from exercising its non-coercive and coercive investigative powers in Part B of Chapter 5 of the Competition Act for purposes of discharging its obligations under the June 2016 order. B. The Commission is directed to file its report with the Tribunal as contemplated in the June 2016 order within 30 days of this order. C. The first and second respondents are ordered jointly and severally to pay the costs of the application, including the costs of two counsel. 3. The appeal against the order of the CAC dismissing the applicant's application to adduce new evidence is dismissed with no order as to cost. 4. The applicant's application to adduce new evidence on appeal is also dismissed with no order as to costs. 5. The Competition Commission's application to adduce new evidence on appeal is likewise dismissed with no order as to costs. I hand down the judgment.
Okay, you've been watching the judgment from the Constitutional Court on the agreement between the SABC and MultiChoice brokered by the public broadcaster's then COO Hlaudi Motsoeneng in 2013. Appeal is upheld.